I said, oh, Greg, I think you got the wrong person. Don't you know anything about me? Did you know that I've written extensively that I believed that the invasion of Iraq was not lawful under international law? He said, oh, yes, I read that. And I said, and Greg, for the last 10 years, I've been dedicating my life to international criminal prosecutions. I help with the Yugoslavia Tribunal, the Rwanda Tribunal, and the Sierra Leone Tribunal, and I helped establish the International Criminal Court, and I've written extensively that Saddam Hussein should be prosecuted before an international body, not a domestic body. And he said, yes, I've read that as well. And I said, so why are you calling me up? He said, well, I figured someone like you'd give him a choice. You could sit on the sidelines and hurl criticisms at what we're doing, or I could bring you on board and see if you could fix it as much as possible. And I said, well, what do you mean by that? He goes, well, we're now producing our rules of procedure, and we'd really like your advice on what needs to be in there to ensure a fair trial. And I said, whoa, that does sound interesting. And then I said, what else? And he says, we're going to need to train these judges. They don't know anything about these unique international crimes, genocide, war crimes, crimes against humanity. And we understand that you've trained judges for the Yugoslavia Tribunal, and the Rwanda Tribunal, and the Sierra Leone Tribunal, and we thought you could help and put together our training program for these judges, and then shuttle back and forth to a secret location and help them learn how to try these cases. And also the prosecutor's going to need some help too, so maybe you could train them as well. And then we thought maybe we'd have a mock trial so that we could do a run-through before they screwed everything up. I said, well, I'd be interested in helping, but I'm a little skeptical. It's sort of like you want to co-opt me as a voice from the outside and make me one of your insiders. And he said, no, it's nothing like that. You can publish and say and write anything you want after you come back from these sessions. And if you think the whole thing is a sham, you go out and say it. So I decided to get involved, and it has been a wild ride, I must say. A lot of you probably have seen snippets of the trial on TV. It is probably the messiest trial of all time, bar none. It's also gone down in history as the most watched trial of all time, surpassing the O.J. Simpson case worldwide by about 3-to-1 margin. In Al Jazeera, which about 50 million Arabs watch every day, it is the #1 rated show from morning to night. So this is an important piece of history, and I'm not sure if we could say it rivals the Nuremberg trials that the Robert Jackson Center is dedicated to preserving the memory of, because Robert Jackson was not only a Supreme Court justice from this area, but he was the chief prosecutor at Nuremberg. But probably in history, when you compare the great tyrants who have been brought to justice, you'll have to put Saddam Hussein up with people like Hermann Goering at Nuremberg, Slobodan Milosevic at The Hague, Charles Taylor, who's now being prosecuted at The Hague. And there aren't a lot of other people that are in this caliber of tyrant who is accused of killing so many people. So I decided to get involved in the trial, which became the messiest trial of all time. And what I want to talk to you today about are sort of some insiders' views and insights. I'll try to pierce some misconceptions about the trial, try to explain why some of the decisions were made, and also describe some of the lessons I think that the people in Baghdad have learned from this trial. Because after all, this isn't the only trial of Saddam Hussein. This is the first of a series of trials. They began with a very small case, and a lot of people looked at this as a judicial laboratory, an experiment. They would see how it would all work, and if they mucked this case up, at least they could fix it for the next one, which is much more important. The first trial of Saddam Hussein involved a crime called the Do Shall Massacre. And what happened was Saddam Hussein in 1982 was the fearless leader of Iraq. He was in the middle of a war against his archenemy, Iran. And some of the people in his country, mostly Shiite, who were a member of the Dawa party, were siding with his enemy, Iran. And when he went into this town that was full of Shiites, he went with his motorcade, and he was smiling and waving to the masses, and some people jumped out from the palm groves and started machine gun attacking his motorcade. And he survived. They sped off. They returned fire. They killed the people who were doing the attack. And immediately thereafter, he ordered the roundup of, quote, the usual suspects, very much like the phrase from Casablanca. So they brought in about 350 people who were family members or members of the Dawa party, including some 8-year-olds and some 10-year-olds who were quite heinous and dangerous, I'm sure. And they put them all in a wonderful place to hang out on vacation called Abu Ghraib Prison. There they rotted for 2 years. During that 2 years, they were interrogated by Saddam Hussein's personal security entourage, and 1/3 of those died in interrogation. Saddam Hussein then felt that this was something worth dealing with, and so he gave medals of honor to the prison guards who were responsible for the interrogations and deaths. Then he signed the order for all of the remaining 148 Dujal residents to be tried en masse in a trial before not an ordinary Iraqi court, but one of the revolutionary courts, which were his secret security courts. And they were tried in a 1-day trial. There was one lawyer representing all of them. They all confessed, big surprise, including the 8-year-olds, the 10-year-olds. And then the judge decided that they all had to have the death penalty. The judge, by the way, sits next to Saddam Hussein in the courtroom, and he is also being prosecuted for the role he played in all of this. And it's the first time in 60 years since the judge's trial, made famous by the screenplay and movie Judgment at Nuremberg by Abby Mann, the person who was supposed to speak to you today. It's the first time since that trial that a judge has been prosecuted for presiding over a judicial system that is being used as a weapon against the civilian population. So then Saddam signed the order for these people to be executed. They all were, and that's just one small incident. And it was only involving 148 people. The next trial, which will begin on August 16th, is going to, or August 21st, is going to involve the Anfal campaign. Now that's a serious, serious event in the history of Iraq. There, over the period of a year, Saddam Hussein launched 8 different attacks against the northern Kurds using chemical weapons, major firepower, in order to destroy all of their homes and their cities, and ultimately 500,000 people were killed. So when you compare 500,000 people that are victims of the second trial to the 148 that were victims of the first case, you can see that they really are starting out small. And yet the first case will be remembered as the test case. It's the one where everything was on the line, the rules of procedure, the statute, the way you dealt with someone like Saddam Hussein. Now, during this trial, there were lessons drawn from both the Nuremberg experience and the more recent Slobodan Milosevic case in The Hague. For those of you who followed the Milosevic trial, he was the Serb leader responsible for ethnic cleansing in Bosnia. And he decided that he wanted to represent himself. He was going to be the Serb Perry Mason. He, after all, had graduated #1 in his law school class. Also, by the way, Saddam Hussein graduated top of his law school class. Coincidentally, almost every genocidal ruler ever brought to justice was a lawyer. I'm not sure what the relationship is. But what it does is it allows them to say they want to represent themselves in the courtroom. They want to be their own lawyer. And what Slobodan Milosevic did is he used self-representation as a way to hijack the trial. Instead of asking questions on cross-examination, he would yell and scream at witnesses and make speeches on cross-examination. Now normally if a lawyer like myself tries to do that in the courtroom, or how many of you are lawyers or former lawyers, by the way? I bet a lot of you are. So if you guys tried to do that in the courtroom, the judge would get a little annoyed at you, and he has certain weapons in his arsenal to control your behavior. For example, the judge could tell you, if you don't behave yourself, I'm going to fine you. And as a lawyer, you don't want to lose money. Or he could say, if it was worse, I'm going to put you in jail for the night, and your wives and families wouldn't like that. Or he could say, I'm going to have you removed from the case and institute disciplinary proceedings against you and have you disbarred. So when a lawyer is in the courtroom, the judge can control his behavior. When a defendant is representing himself, there is nothing the judge can do, practically, to control the behavior except send the defendant out of the courtroom. But since the defendant has a right to be present in his trial, that means the trial has to end. And because they don't want the trial to end, they want the case to go on, what it meant in the Milosevic case is that they gave him a lot of leeway to hijack his trial. Well, we wanted to avoid that in the Saddam Hussein trial. So what we did is we wrote a long memo from Case Western Reserve to the judges, and it was translated into Arabic, and it went to the legislature. And it described why, under international law, someone charged with these kinds of crimes should be represented by a lawyer in the courtroom and doesn't really have an overall right of self-representation. A right that we do have, by the way, in the United States, but it's a qualified right. In the United States, if you exercise your right of self-representation, but you act disruptively, or you say terrible things to impugn the integrity of the judge, you lose your right, you forfeit it. And that's exactly what Milosevic had done. And we thought that Saddam Hussein would try the same thing. Now, the legislature of Iraq actually passed a law, the Statute of the Iraqi High Tribunal, in which they said, we're going to require all the defendants to be represented by lawyers and that the lawyers do all the speaking. And we thought that solved the problem. So this is the first lesson that we learned from the Saddam Hussein trial. The folks in Iraq who are trying this case are independent judges. They are not the puppets of the American puppet masters. If that were the case, the trial would not have gone as it did. Instead, they do things like they're used to doing in Iraq. And everywhere around the world, there's a different legal culture. There's a different way of doing things. Well, in Iraq, after your lawyer asks questions, traditionally, the defendant then gets to stand up and ask questions. And whenever the defendant wants to address the court, the defendant's allowed to address the court. That's how it's done in Iraq. We didn't know that, because I had never seen a case unfold actually in Iraq. And so we thought that when we passed this law, we had solved the problem. In fact, the judges in the very first day of trial circumvented what we tried to achieve and allowed Saddam Hussein to jump up and ask questions which turned into speeches, which ended up allowing him to disrupt and distract and hijack the trial. So what we're hoping is that in the next trial, we can convince the judges to depart from the ordinary Iraqi way and understand that this kind of case is unique in such a way that it would be better for someone like Saddam to only be allowed to speak at the end of the trial when he testifies on his own behalf, like it is done throughout the rest of the world. So that's lesson number one, and the lesson is twofold. One is you have to understand you're dealing with a different culture, and second, you have to understand that when you allow the defendant to represent himself or to have an opportunity to speak throughout the trial, and these are televised trials, you're just opening the door for the kind of chaos in the courtroom that ensued during the Saddam trial. Now, also in the area of lessons involving culture, there is an important need to sort of control the lawyers in these cases. And the lawyers in the Saddam Hussein case were an extraordinary bunch. They included Ramsey Clark, the former Attorney General of the United States. They included a Minister of Justice from Malaysia, and about 100 of the top defense lawyers and human rights lawyers in the world. Now, lawyers have different motivations, maybe, for taking on a case like this. You're probably thinking to yourself now, if you were a lawyer, would you want to represent Saddam Hussein? Well, I think there may be three reasons a lawyer would take on such a case. Maybe someone like Alan Dershowitz, the famous Harvard law professor who takes on those impossible-to-win cases, would take it on just to prove to the world that he was up to the challenge and he could maybe eke out a win against these great odds. And then there are lawyers who are dedicated to human rights and due process, and they will take on a case because they believe that any defendant, no matter who it is entitled to a good defense. And that at the end of the day, the process is better if arrayed against the prosecutor is a superb defense counsel, doing all that the defense counsel possibly can. And there are some of Saddam's lawyers that fall into that category. A third category might be lawyers who want to become superstars, famous throughout the world, household names like Johnny Cochran from the OJ case. And there probably are some people that joined up for that. But a fourth category would be what I think Ramsey Clark falls under. And basically it's this. Ramsey, like myself, was against the invasion of Iraq. But Ramsey thought, unlike me, that this trial was the perfect vehicle to tell the world what a terrible thing the United States had done. So he wanted to transform the trial into a trial of George Bush. Some people might applaud him for that, but it's not necessarily in the best interest of his client who's trying to get an acquittal or even save his life because execution is a possibility. So you have Ramsey Clark and these other lawyers with different agendas, and they were as disruptive as their clients. One of the things that almost everybody did during this trial is walked out. And when we saw that happen on TV, we were thinking, geez, look at the chaos in the courtroom. The people are walking out. At one point, the prosecutor walked out. At another, the judge resigned. He staged a walkout. He was replaced. The defense counsel walked out on numerous occasions. And we're all shocked. How can you have a trial when everybody's walking out? What I learned through my process of training the judges and getting to know the judges is that one of the things in the Iraqi culture is to stage walkouts. They do it all the time. For example, during the training session, one of my colleagues was saying that the judges had to be very strict about following a certain rule. They said, this rule is so important you have to be like a pit bull about it. And the translator stopped and said, pit bull, we do not know what this word is in Arabic. And my colleague said, oh, you know, the pit bull is the dog that bites the neck and does not let go. And so the translator stared at us for a minute. You want me to say that? Yes, go ahead and say it. Okay, you have to be like the pit bull, the dog that bites the neck and does not let go. Suddenly, all of the judges got up and left the room. We ran out in the hall. We said, judges, why are you leaving the room? Translator, translate that. And the translator said, well, you insulted them. It turns out that the worst possible thing you could ever say about Iraqi was to compare them to a dog. So we brought them back in and we said, we're really sorry, we didn't get that cultural thing. So what you need to be is like the tree frog. Do you know what a tree frog is, we said? And the translator said, oh yes, they know the tree frog. In the marshes of southern Iraq, there are many tree frogs, many tree frogs. So we said, well, you have to be like the frog that sucks on and does not let go. And everybody nodded their head and they smiled, and we got through that. I thought that might have been just like a one-time deal, but at the same time I was training the judges at this secret location in England, my colleague who, together we run a non-governmental organization called the Public International Law and Policy Group, was out in Baghdad helping to redraft the Constitution at the request of the Parliament, and trying to find some compromises so that they could adopt the Constitution. He told me that every single day, at least once, if not 10 times, a different group of legislatures would stage a walkout. And he said, it's like it's in the water in Baghdad. They just like to walk out. And this is not unique to either the legislature or my training sessions that happened during the trial. And what it does is it lets us see this event through a little bit different eyes. We understand this is something Iraqis do. It didn't mean that the entire trial was like a travesty. But the judge actually figured out a good way to solve this problem. And this is one of the lessons also of the Saddam trial. He said that he would appoint standby lawyers who were public defenders who would be in the trial from day one to the last day. They'd be very distinguished defense counsel, and they would be assisted by international advisors from the International Bar Association from many different countries. And if ever the defense counsel staged a walkout and the judges said, you can't walk out, you must stay and defend your client, then the judges would say, if you walk out, you forfeit your right to defend your client, and we will turn it over to our standby defense counsel. Now, unfortunately, the Iraqi High Tribunal did not have a PR unit, a public relations unit. And these events, when they were described in the courtroom, weren't good television, because nowhere was this reported in the West. And what we heard instead is that there were some really bad defense counsel that at the last second were brought in to give the closing arguments for Saddam Hussein. That's not what happened. And in fact, the closing arguments that were given were extraordinarily well done. Much better than Saddam's actual politicized, high-powered superstar lawyers would have done, because the agenda of the appointed defense counsel were to win the case in the courtroom and not simply to embarrass the United States. So there was a lesson there as well, both cultural and about how to try to control a courtroom in this extraordinary kind of case, and also a lesson about the press, because this kind of stuff just didn't get reported. And if it wasn't for the fact that I am in close touch with the people in Baghdad, I wouldn't know the full story of what was going on. Well, one of the other interesting things about this trial, a lot of people look at this and they say, well, how can he get a fair trial? You know, if there's a conviction, it's not going to be fair. The case ended up not being about witness testimony, but rather about documents. In that way, this case was very much like Nuremberg, where the Nazis convicted themselves on the strength of their own documents. Saddam Hussein, it turned out, documented everything. And before the trial, I thought he was sort of a Richard Nixon-like guy who would tell people, you know, or a mafia leader, he would say to his subordinates, you know what I want done, make it happen. But no, he said, I want you to pick up 300 people, whether they're guilty or not, and I sign my name to that order. I want you to torture those people. I sign my name to that order. I want you to have a Medal of Honor because you did such a good job killing and torturing those people. I sign my name to that order. I want you to try them in a special court, in a one-day trial. Signed Saddam Hussein. And ultimately, I want you to execute all of them. Signed Saddam Hussein. During the case, there were discussions about authentication. They brought in experts who testified that this was, in fact, Saddam's signature. Saddam, on March 1st, at this very moment in the trial, stood up in the courtroom. You may have remembered this moment reported in the press. And he said, of course it's my signature. Of course I signed those documents. I am responsible. This was sort of the a few good men moment of the trial, right? With Colonel Jennings, where he said, you want the truth? You can't handle the truth. And then he admitted everything from that movie and Broadway play. Well, this is what Saddam Hussein ended up doing during the trial. Now, that wasn't an admission of guilt, because he went on to say, and the defense spent the rest of the trial trying to prove, that any president, any leader of any country, faced with terrorists, faced with an insurgency in a town during a time of war, would do the exact same thing as Saddam Hussein. And in that way, this trial is a much more important case than just the 148 people who were killed. This trial is really about where do you draw the line in the war against terror. And it's not just where does Saddam draw the line and get away with it, it's about where do we draw the line. Abby Mann, who was supposed to be here today, who wrote the screenplay for Judgment at Nuremberg, ends the movie with a statement by the chief judge where he's explaining why he's going to convict the defendant, who's played by Burt Lancaster. And the chief judge says, in the life of every nation, there is a time of crisis. But a country isn't a rock. It's not an extension of oneself. A country is what it stands for. It's what it stands for when standing for something is the most difficult. And what he was talking about was not about Nazism, because he wrote this screenplay during the 1950s. He was talking about McCarthyism. But so much could also be talking about what's going on in our own country today. And just a week ago, I was asked to testify before the House Armed Services Committee, to testify about the Al-Qaeda military commissions, in light of the fact that our Supreme Court had just ruled that the president's conception for those military commissions violated the Geneva Conventions and therefore were not legal in the United States. And so I went up there, and one of the questions that the judges, or that the congressman asked me is, you know, why do we care if we violate the Geneva Conventions? Congress has legal ability to pass a law that supersedes an earlier treaty that the United States ratified. Why not just pass a law and allow the president to have these military commissions? After all, we're fighting the war on terror. And when he said that, I could only think about Abby Mann's screenplay, about the trial that's going on across the world in Iraq, and about the fact that around the world, the United States has really taken a huge hit in terms of its moral authority. A couple of weeks ago, I was teaching students in the Netherlands, and we visited the United States member of the International Court of Justice in the Peace Palace. And the judge, Thomas Bergenthal, was answering questions, and I asked him a question. I said, has the United States actions, which have been seen as violating international law, affected you, or have you seen an actual physical effect, a practical effect in America's diplomacy? And Judge Bergenthal, and I guess this is sort of off the record, so you probably wouldn't want me saying this for the press, but what Judge Bergenthal told us was that he was a very popular judge because he had been the president of the Inter-American Court of Human Rights, and everybody had known him as a law professor, and he had many friends around the world. And worldwide, he had actually voted 3 times in 3 different cases against the United States, so he was known as a very independent-minded judge. So normally, he would have a cakewalk to re-election. But when he was up for election just a year ago, it was a really tough fight. Because he said he wasn't fighting against his judicial precedent, against his reputation, but rather about the fact that the United States had sunk so low among our traditional allies, our closest friends, and other countries around the world. And he said, I did win re-election narrowly, but we didn't get elected to the Human Rights Commission. We lost an election to the Finance Committee of the United Nations. And around the world, things that the United States is trying to do diplomatically, it's finding it more and more difficult. So the Congress people kind of understood why it's significant from that point of view. And then I told them another story. I said, how many of you Congress people have daughters? And almost half of them raised their hands. I said, how many of them are in high school or college? And a lot of them kept their hands up. And I said, do you guys know the story of Lori Berenson? Lori Berenson was an MIT student getting her PhD. She went down to Peru to do research. And through a bunch of strange circumstances, she ends up being brought to trial before the Peru version of the US military commissions. So she has a trial with judges who she can't see. She's not allowed in the courtroom. She doesn't get to know what the evidence is against her. She doesn't get to cross-examine the witnesses. She doesn't even get to talk to her lawyer. Just exactly like what's going on with the US military commissions that the US Supreme Court said violated the Geneva Conventions. Well, for a while, we were trying to get Lori Berenson out of Peru. We were doing a lot diplomatically, and it looked like we were going to succeed until we instituted the military commissions. And then the Peru government said to the US government, what are you complaining about? Our commissions and your commissions are the same. And we just dropped the ball on that issue because there was nothing more to be said. And so I said, you know, when your family members travel around the world, members of Congress, this decision that you have to make, whether to reapprove the military commissions in a way that are in violation of the Geneva Conventions, or fix them so they correspond with due process, could actually come back and affect your family members when they travel. So this international law stuff has practical consequences. And that's one also of the very important lessons of the Saddam trial. When the judges look at Saddam's defense, that he was just acting as a leader, he was doing what was necessary in the war on terror, the judges are going to have to decide where do you draw the line between what is necessary and what is just not going to be tolerated because it violates the most important principles of humanity. On that issue, with 20 minutes left, let me end my formal part of the discussion and open it to question and answer and hear what you all have to say. I look forward to our discussion. After Nuremberg, there was hope that, and there was a saying that emerged called never again. And the hope was that never again would the international community stand by and allow these kinds of international crimes to occur without bringing people to justice. It was a pledge that they would. But the hope of never again, the pledge of never again, turned during the Cold War into the reality of again and again. And so people like Fidel Castro and Pinochet in Chile, and Baby Doc and Papa Doc Duvalier in Haiti, and bigger perpetrators like Pol Pot, Cambodia, or Idi Amin in Uganda. And the biggest of all, probably, are Mao in China and Stalin in the Soviet Union, got away with committing these same kinds of atrocities, and during the Cold War, nobody lifted a finger, nobody said a peep. Now, in 1993, when I was working at the State Department, genocide returned to Europe for the first time in 50 years. And they decided to do something about it. They created an international tribunal. Now, really and skeptically, some of the people in the US government didn't think the international tribunal was going to be more than a PR vehicle. But these instruments of international law take on a life of their own, and Slobodan Milosevic ends up getting tried before the tribunal. And it looks like very soon his henchmen, Ratko Mladic and Radovan Karadzic, will also be tried. And after the Yugoslavia Tribunal was created, genocide broke out in Africa. And again, cynically, I'll tell you this. If the genocide in Africa had preceded the genocide in Bosnia, I don't think they would have created a tribunal. But what happened was the Prime Minister-elect, who was a Tutsi, came to the Security Council, and he gave a speech that I will never forget because I was there, and he said, "Is it because of the color of our skin? Is it because we are just Africans that you do not create a tribunal for us, but you create one for Yugoslavia?" And the Security Council was shamed into creating a second international tribunal. And once you had two, then the momentum created. There was a new one for East Timor and for Sierra Leone, and there's a new one for Cambodia. And then there was the Permanent International Criminal Court that was negotiated in 1998. And the United States decided it didn't like the idea of a Permanent International Criminal Court because it itself might be brought before such a court. So the US tried to make the court go away, but sort of like the Grinch who tried to keep Christmas from coming, the court came. He couldn't stop it from coming. And there are 100 now countries, including all of our major allies in NATO, that have ratified the International Criminal Court. And then just recently, the United States allowed a case to be sent by the Security Council, the Darfur situation, to the International Criminal Court. So what I'm saying in a long wind-up to answer your question is that we've gone from an age of impunity where somebody could, according to the UN, have a better chance of being convicted for killing one person than for killing 10,000 or 100,000 or 1 million, to a new golden age that's just beginning of accountability, where leaders are starting to look over their shoulder and feel, oh my gosh, I might be held accountable. But even more important, their subordinates, the generals who are under them, are feeling that. And now we won't have the situation in 1939 when Adolf Hitler told his commanding officers, we're going to go into Poland and do total war and take mobile gas concentration camp and murdering devices with us. And the general said, oh, we're not comfortable with that. And Adolf Hitler said famously, well, don't worry, who after all today remembers the Armenians? He was saying, look, the Turks killed a whole bunch of Armenians, maybe 500 or 800,000 during World War I, and no one prosecuted them. They gave them amnesty in the Treaty of Lausanne. We can do it too. Well, that's not happening anymore. So the generals are starting to get really nervous. Unfortunately, we're not to the point yet where everybody around the world is subject to international criminal law. So a place like Cuba has not ratified the International Criminal Court statute. So unless the Security Council refers the case of Cuba or Castro or his brother Raul to the International Criminal Court, they're not going to be prosecuted. And China has been a very close friend of Cuba since the Soviet Union fell apart. They have a veto at the Security Council. They will not allow that to happen. On the other hand, there's something called universal jurisdiction, where more and more countries are starting to prosecute people or indict people for crimes that are against international law but don't occur in their territory. Belgium was doing this left and right a couple of years ago, but they went too far. They indicted Henry Kissinger and George Bush Sr. And the United States said, look, if you don't rescind those indictments and change your law and stop using universal jurisdiction, we're going to move NATO headquarters to Germany from Belgium, from Brussels. So they did that under that kind of pressure, which is a little bit unfortunate. I mean, I don't think it would have been good for them to prosecute our former leaders, but it's unfortunate that they no longer exercise universal jurisdiction. Spain, on the other hand, has a Judge Garavan who keeps indicting people left and right from Latin America. And it is possible that someone like Fidel Castro could fall into his sights. So that's a long answer to a good question. The way the International Criminal Court works is that a country has to ratify its statute like a treaty before the country is subject to the court. And the United States has not ratified the ICC statute, even if there's a change of administration and they decide, they wake up and they say, oh, the International Criminal Court's a wonderful thing. It probably will be years and years before we ratify it. I should say, though, patience in this area is all right because it took the United States 38 years to ratify the Genocide Convention after World War II. So it may take a while for them to ratify. The ICC, however, has another way that it can exercise jurisdiction, and that is when the Security Council of the United Nations votes to send a case to the ICC. And it can be a case from a country that hasn't ratified, like Sudan in Darfur. When the United States decided not to veto last spring the effort to send the Darfur case to the ICC, the United States really did a whole 180. And instead of trying to kill the ICC and saying it's an illegitimate institution, the United States said, well, it may not be for us, but we'll live with it, and we will use it in appropriate situations. And that moves us along a continuum towards support. Right after that, I was asked to go to an interesting CIA meeting in Maryland, in Wye River, Maryland. And the issue was, they had all these experts in there, and the issue is, how do we live with the International Criminal Court after Darfur? Really what they were saying is, how do we co-opt the ICC? And my argument was, if you want to live with it, if you want to co-opt it, if you want to make it our friend, what we need to do is support it, not try to combat it. The judges of the ICC will be much more sympathetic to the United States if we're cooperating with it than if we're trying to crush them and put them out of existence. And in fact, since that time, the second prosecutor of the International Criminal Court who was appointed, the number 2, is an American, and that's not a coincidence. I mean, they're making overtures. And the president of the International Criminal Court is Philippe Kirsch, who is a Canadian, and he actually came out to case in the spring, and having spent a couple days with them, I think what we basically have, Canada and the United States would share a lot of common cultural and historic origins. And it's like having another American being the president of the International Criminal Court. It's the closest thing we could have. So, I think that what the United States is going to do is have sort of a wait-and-see attitude. But even the Bush administration, with the exception of one guy, John Bolton, who still hates the International Criminal Court, but the rest of the administration has come a long way. They've changed their opinions on it, and I think it's a good sign. Thanks for the question.